Well, good evening, everybody. I am attorney Michael Ehline, and I'm a natural law rights attorney. I practice personal injury law and civil rights claims like tight handcuff cases. And I'm just going to try to fix the screen here for you. It's kind of doing its own thing. Hopefully you can see that.
Good evening, everybody. I am attorney Michael Ehline, and I'm a natural law rights attorney.
So
I practice personal injury law and civil rights claims like tight handcuff cases.
I'm still trying to
And I'm just going to try to fix the screen here for you.
sort of learn how to use Restream.
It's kind of doing its own
So
thing.
I came on early for this purpose, so
good evening, everybody.
don't get upset.
I'm a natural law rights attorney. So I practice personal injury law.
Let me try and square everything away.
Trying to. I'm just going to try to fix the screen here for you.
Sort of learn how to use Restream.
It's kind of doing its own
So
thing.
I came on early for this purpose, so don't get upset. Let's try and figure out why we're getting this background noise here.
Try and square everything away. Sort of learn how to use Restream.
Bear with me.
So I came on early for this purpose, so don't get upset.
Let's try and figure out why we're getting this. Once I
background noise here,
eliminate the problem, I think we got it. I had YouTube open in another tab there, so it was playing. Let's see if we've got anybody in the chat yet. We'll go ahead and throw it up. There we go. Hey, what's up, Jody? So sorry about the little rough beginning there. I'm attorney Michael Ehline, and I'm a natural law rights attorney, and I do civil rights, police, tight handcuff cases, personal injury law. I like to talk a lot about fiat currency, the Second Amendment, where our rights come from, what natural law is, where your rights really came from, which is your creator, just like it says in the Declaration of Independence, which was incorporated by reference in our Constitution, just like the Magna Carta and all the founding documents of English common law that passed into American tradition, except were abrogated by the Bill of Rights, which is something you'll never learn in the public schools or in a Marxist-run university. So this is where you'll get the alternative view, the non-revisionist history view of America and what makes America such a wonderful place, what made it such a wonderful place until around 1913 with the establishment of the secret, private Federal Reserve Bank, which the Supreme Court says is quasi-private, quasi-government, but the Constitution makes no provision for a quasi-government, quasi-private institution. So, hey, Stomper, good seeing you. Que pasa, Steve? So we're starting a little early because I wanted to give you a little bit of history about this guy next to me before Alan Beck shows up. And so I just wanted to thank you guys. About a year ago, you joined me where we discussed the Wolford case with Alan Beck, who is the actual petitioner's attorney in the state of Hawaii. And so in order to understand the Wolford case, we need to understand the government's argument. Just like the state of California argued that gun laws are valid historically in California because they were restricted to Indians, they're arguing the same thing with Hawaii, basically, that since the king of Hawaii outlawed firearms, that means there's a historical precedent to outlaw firearms in Hawaii because it's based on the historical precedent. That's the way the law works now, since people like Alan and Dick Heller of District of Columbia versus Heller, who's also a good friend of mine, Dick Heller. Tried to get him on for interviews in the past, but just haven't been able to make it happen. But I do go to him. I do hang out with them at the Gun Owners of America over at the SHOT Show in Nevada whenever he comes into town. So really quickly, and now Alan's supposed to join us when this show is scheduled to go live. Well, look, Steve, you're preaching to the choir, man. Steve says if the Constitution actually meant anything, we would not have been invaded and we would not be almost 40 trillion in debt. Well, remember, that's fiat currency, so it's not real money. All the governments, all the Federal Reserve Bank has to do is print more fiat currency, and that will cause the dollar to devalue. And in fact, since 1913, since the creation of the Federal Reserve, what's happened? The dollar has lost 99% of its value. Whereas if we had just stayed with gold, that same $20 gold piece that could have bought you a fine Italian suit, a nice meal, and a lot more could buy you the same thing today. That's the difference. So the gold maintained its value over time, whereas the dollar deflated. And that's how the government pays off its debt, by devaluing the currency. You take out a $500,000 loan, the Federal Reserve Bank causes inflation, that $500,000 loan, because your wages have to go up and prices have to go up to keep up with inflation that caused by the Federal Reserve Bank, not tariffs, by the way. Then that loan amount actually goes down. And that's kind of how they do it. It's just a big shell game. Hey, Ryan Labs, good seeing you. So before Alan comes on, I want to get into a brief history of what the state of Hawaii and the U.S. government wants to argue. And just to let you know that although I know a lot of you guys don't like Trump, you know, I'm a libertarian, so I think that Trump is basically a old school Democrat, a tax and spend Democrat, but conservative compared to the modern Marxist Democrats. And he governs like a Democrat, tax and spend. So I don't really see much of a difference, but you guys tell me what you think. But this show is intended to be nonpartisan, and I want to give you a brief history before Alan shows up of what the king did and what the government's arguing against, well, what the state of Hawaii is arguing against Alan Beck. And Trump's Department of Justice has joined Alan Beck against the Ninth Circuit, saying, no, we think that concealed carry laws should be constitutional, like the Constitution says. The right of the people to keep and bear arms shall not be infringed, right? And militia, well, every male over 16 years old was automatically a member of the militia, and we had regular militia and irregular militia. Regulars would have been like the Continentals, and irregulars would be freeborn Americans like you and me. Another thing they don't teach you in the Marxist-run academic education system or in public schools. So let's get into the history really quick. And I want to thank everybody for the feedback on my last videos. As you know, I'm out in El Salvador, having a great time, eating good food, training with weights, doing everything I can to keep the body fat down, high protein, all that stuff. But it's your right to push back on the revisionist history that's taught in modern academia. And it looks like Alan's already joining me. Hold on a minute. Let me see if I can get him in here. I see him there, but again, there we go. Hey, Alan.
Hi, Mike.
Hey, so everybody, this is Alan Beck, and he is lead, and it's his case, the Wolford case. Alan, I was just getting into a brief history of the King of Hawaii and how these Hawaiian gun laws came into effect. Do you mind if I spend a few minutes explaining it to him, and then you can pop in?
Yeah, absolutely. I mean, you can. I didn't realize you were gonna let me in. I just wanted to make sure I got here.
Oh my gosh! Well, you know, I can pop you out, or you can stick around and help me if I make any mistakes.
Yeah, whatever would be good for you, Mike.
Yeah, I'm totally cool with that. So we've already got some people in the chat, which is really exciting because I came in early, but we got my regulars in here. As you guys see, I have it in horizontal because I'm going to make some videos out of this instead of just regular shorts. But just really quickly, I'm going to get into a short history of the non-revisionist history that the state of Hawaii would have you believe, and what a lot of the public schools and academia teach. I'm going to get into the real history of how guns got banned in Hawaii, and I'll let Alan pop in whenever he wants. But first, the ban itself. In 1833, Kamehameha III, the guy you see over there on my screen, decreed that any person or persons on shore couldn't possess weapons like knives, swords, canes, or deadly arms without good cause. Penalties included fines, imprisonment, or even lashings. Now, official records, which I believe are pretextual records, tied this directly to curbing chaos in ports like Lahaina and Honolulu, where whaling ships unloaded armed sailors, often intoxicated. So allegedly, these foreigners brought guns and blades, which the citizens already had, by the way, leading to brawls and assaults on locals and threats to Hawaiian sovereignty, according to the king. So the kingdom lacked a modern police force, so this was a blunt tool to maintain order, disarming everyone, throwing out the baby with the bathwater to neutralize the outsider threat. But was it just a convenient excuse? Let's look at the timing. 1833 was a powder keg for the young king. At 19, he was fresh off the death of his regent, King Ka'ahumanu, in 1832, and he elevated his Aika'ane, and Alan, I'm not good at Hawaiian, and you know Hawaiian better than me. Hopefully I said it right. Kaomi, a Hawaiian Tahitian with priest-like ties, to co-ruler status, granting him, it was a dude, authority over land and resources. And this sparked outrage from Christian missionaries and traditional chiefs who saw this as a slide into heathen ways, reviving the hula, rum, and gambling. Tensions boiled over with armed confrontations. Chief like Kina'au stormed the palace, weapons in hand, nearly assassinated Kaomi, forcing the king to defend him personally. So you see there already, it was the local Hawaiians who were uprising. So think about that, okay? So in March 15th of 1833, amid this mess, the king issued a separate decree claiming absolute power. The country is mine. I shall rule. Neither chiefs nor foreigners have any voice. This was a direct shot at the co-regency system and missionary influence, reasserting solo control. Kaomi eventually stepped down to avoid civil war, dying soon thereafter. Now, connecting the dots, historical accounts don't explicitly link the weapon ban to this internal drama. It's framed as a response to external violence, but what was the effect? Well, now you're onto something. By broadly restricting weapons on shore, the king indirectly limited armed dissent from chiefs or rivals during a volatile period. Armed groups could not easily escalate palace standoffs, and it centralized control under the monarchy. In a kingdom without a standing army, this could have helped neutralize threats to his rule. Even if sailors were the alleged target, it didn't really matter. It's modern pretextual laws. Public safety is a cover for broader control. It's basically, that's all it is. It's like a modern pretextual law couching public safety as a cover for broader control. Still, sources, the left at least, the government, emphasizes the sailor issue is genuine, with the power grab happening through other decrees. But the ban's real legacy, it set a precedent for heavy weapon regulation in Hawaii, prioritizing communal harmony over individual arms. And so modernly, what's going on, and Alan, go ahead and tell us a little bit about the modern case that changed everything. Now everything has to have a historical precedent in order for a gun law to be valid. Tell us about that.
Well, in about 3 years ago, the U.S. Supreme Court issued its landmark opinion in New York Rifle and Pistol Association v. Brune. And
that's the Bruen case, right?
Yes.
That's Bruen?
That's correct.
Okay.
And in Brune, the Supreme Court found that any gun regulation that implicates Second Amendment right needs to have a historical analog. And a little more than that, the government needs to be able to point to a historical tradition of firearms regulation of a similar manner. So what that means when they say historical tradition is, and that'll be relevant to the conversation we have later, is the government can't just point to one law in, Pensacola, Florida in 1823 or whatever and say that's fine, because that would be considered an outlier law. The Supreme Court actually expressly disavowed the use of outliers, territorial laws and whatnot, and said it actually has to be historical tradition. So you have to show, a broad pattern. They didn't say how many, but, more than one, more than two. That's certainly the case. And so that's been the law for the past 3 years, is that in order to justify a firearms law, the government needs to be able to point to history.
And when you talk about history, you're talking about American history under the Constitution, not an ancient Hawaiian law that was designed to disarm its citizens, right?
Well, yes, and we'll talk about that a little bit later, but the Supreme Court very expressly said that a it has to be an American national tradition. So, yes.
And tell us a little bit about your case, the Wolford case, and the history of that case, if you could.
So, Wolford is a broad challenge to a number of laws that were passed after the Brood opinion. And after Brood, the governments in the non-issue states, New York, New Jersey, Maryland, Hawaii, California, etc., had to start issuing CCWs. And I had a case that also went to the Supreme Court right after Brood called Young v. Hawaii that dealt with the Hawaii CCW law. And so after those cases were decided, permits have to get issued now in Hawaii and these other states. So
now, when you say CCW, Alan, I hate to cut you off, but a lot of my audience might not know what CCW means. Can you tell us what that means?
Concealed carry weapons permit.
Okay.
So a permit to be able to carry a handgun concealed.
Or a blade, right? Maybe.
In some states, it'll apply to a blade. I mean, for purposes of this podcast, when I refer to CCW, I'm referring to handgun. I mean, that gets a little bit more complicated. You have to do a state-by-state, analysis. But pretty universally, when someone says CCW, at the very least, it refers to handgun.
Okay.
And yeah, it's anyway. So what they did was they made a bunch of locations no carry locations, parks, beaches, restaurants serve alcohol, banks, and parking lots that are adjacent to those locations. What I challenged, but we're not going to the Supreme Court on that. What we did was there was an additional law that is the most egregious of all these laws. It says that a private business any private business has put up a sign saying guns allowed in order for you to carry there. And look, the reality is no one puts up these signs. So what I did is I filed a temporary restraining order a few days before this law was going into effect. And asked the injunction for all these locations. The signage law, which will be which is what the Supreme Court's going after, what the Supreme Court is going to review, along with these other locations, which are simply complete bans on carry. And so the matter so we went to the trial court. I got a temporary restraining order against all the laws we asked for. The state appealed it up to the Ninth Circuit. And just so I'm real specific, what happened, technically it was converted into a preliminary injunction, which the Ninth Circuit then reviewed. The Ninth Circuit overturned the trial court preliminary injunction on certain locations, no issues. I won on 2, I lost on 3 laws, bottom line. And one of the laws the Ninth Circuit reversed on is this law right here, which says you have to put up a sign in order for someone to be able to carry on your property.
So Alan, so you have to expressly put up a sign on your store saying guns allowed in this store, or they're not allowed? Is that?
Or you otherwise give affirmative consent.
Okay.
Which sort of gets into part of the argument here. It sounds easy, right? You ask a guy if he can carry a gun at his store. Well, what if there's a parking lot? Are you supposed to go to the edge of the parking lot? This law covers all private property. So you can't even go onto the private property, the parking lot, to ask for permission. You've got to either be at the edge of the parking lot with presumably a bullhorn and say, I would love to carry, and hope that someone responds, or they put up a sign. So the only real practical way to carry is if a business puts up a sign, even though the state wants to make a big ado about the fact he'd asked for affirmative consent. Otherwise, I mean, let's be honest here. You go talk to the 19-year-old supervisor at the donut shop, and right, I mean, is he really going to just on the fly respond to you? So, as my understanding is that nationally, where this law has been implemented, less than 1% of businesses put up a sign saying guns allowed. And I need to go into the other cases. As I said, New York, New Jersey, and Maryland all had laws, identical laws, all have identical laws to the one at issue here. And the Second Circuit, the Third Circuit, and trial court of Maryland enjoined all those laws and said those laws are unconstitutional, violation of the Second Amendment. The Ninth Circuit was the only circuit to uphold what I refer to as a default rule law. And, well, that created a conflict between the circuits. And under Rule 10 of the U.S. Supreme Court rules, the number one reason the Supreme Court will review something is if federal law means something different in two different parts of the country. You can't have the First Amendment mean one thing in Maine and another thing in California. The whole job of the Supreme Court is to create uniformity in federal law across the nation. So I identified a circuit conflict between the Second Circuit and the Third Circuit with the Ninth Circuit on this question presented. And
so Alan, that's called a jurisdictional split, right?
Yes, I typically refer to it as a circuit conflict or a circuit split, but
Okay.
right. But I've never heard it referred to as a jurisdictional split, but that's probably could be used as well too.
Okay.
But and identified the circuit conflict and asked the Supreme Court to review. And well, the Supreme Court did review. So here we are. We're have filed our opening brief with the U.S. Supreme Court, and the state of Hawaii has filed its response brief. And right now, I'm preparing my reply brief, and that will be the last paperwork submitted to the Supreme Court. That on January 20th, I will be going before the U.S. Supreme Court and arguing this matter on behalf of my clients. And all three of my clients are residents of the county of Maui, the island of Maui, which is also a county that encompasses a couple other islands. And, they all have CCWs. They were carried just fine for about a year after the Bruin opinion. Then the state of Hawaii put in this onerous restrictions. And, thankfully, we still have a restraining order in place, so they can't carry to this day. But, the whole point of this case is to keep them carrying so they can exercise their Second Amendments. And this is just truth. Ever since we put in, they started issuing permits, there have been no issues. The state of Hawaii is afraid of, a fantasy that they've concocted in their own mind that somehow these very dangerous people are going to be walking around just brandishing firearms. The reality is, this is part of the briefing. My clients, along with all CCW, are the safest demographic. They get a lot of training as a requirement, and most of these guys get a lot of training because they want to. None of them have ever been convicted of a serious crime. They don't abuse drugs or alcohol. They're mentally fit. These are all requirements they have to prove in order to get these CCW permits. So, and they have a lower arrest rate on average than police officers. So there's just...
Well, hold on a minute, Alan. I mean, how come I don't hear about any of this on CNN or PMSNBC?
Well, this might come as a shock to you, but it might be that CNN doesn't want these statistics to get out there.
And by the way, Rhinelab says, very good job at getting heard by the Supremes. And Jody says, Michael, always good to see you. Always good to see you too, Jody. Go ahead, Alan.
So, yeah, I mean, that's where we're at, The state of Hawaii has filed their answering brief, and they made some pretty interesting arguments in there, as we discussed earlier, Mike. Probably the two points that honestly are just, to me, a little shocking is one, they've endorsed the use. They have to come up with historical analogs. And, they only came up with two that the Ninth Circuit believed in. And one of our arguments, two isn't enough, but even if they are, these two aren't very good either. One of them is a 1865 Black Code. For your viewers who don't know what Black Code is, that refers to a series of laws that were passed right after the end of the Civil War that were expressly designed to disenfranchise African Americans that had just been freed from slavery, because the southern states didn't want them to be able to exercise their constitutional rights, especially the right to firearm carry. So state of Hawaii has actually defended its law. They concede that is a Black Code. In fact, Mike, at some point, it'd be nice if you could pull up from their brief and put up for everyone to see where they defend. Hey, I can look it for you, and you can just put up for the whole world to see that the state of Hawaii is saying we acknowledge we're using a Black Code, and this is absolutely okay.
Well, I'm going to search for it now while you're talking. I see a lot of amicus briefs on here. Here's what I'll do. I'm going to share the screen right now. Hopefully you can see.
Yeah, I want you to scroll down. Keep scrolling down.
Yep.
Keep going down.
Man, you got a lot of amicus briefs.
Yeah.
Holy crap.
A lot of people care about this case. So go to brief of respondent. Go to December 17th.
Okay. And by the way, can you tell the audience what an amicus brief is?
An amicus brief is a friend of the court. That is a brief written by a third party that has an interest in the case and wants the Supreme Court to listen to them and rule in a certain way. So here we have an amicus brief from the United States. The Trump administration has come in support of me, and they will also be arguing. We also have an amicus brief on behalf of what's effectively 25 states in support of me. It's 24 states plus the Arizona legislature. I don't know how their politics works there, so I'm just going to call them 25 states.
Yeah.
So that's over half the country in support of me. And right. And on the other side, they only got, I want to say it was like 7 or 8 states to go on to defend them, and bottom line. So that's the one law that I found pretty shocking they'd be using.
So they're using that. I wonder how Ketanji Brown's going to feel about that, because we know we know that she's not exactly a supporter of the Second Amendment. So this will be.
We actually don't know that.
Okay.
We can infer that, but
yeah.
I mean, we don't have a lot of track record on what Justice Jackson thinks about the Second Amendment, so she could surprise us, right? I mean,
yeah.
I certainly would. I'll find it interesting to see how the Black Code argument goes over with Justice Jackson, frankly, all the justices.
Yeah.
But it's so I am going to
tell me where to scroll down to. What page?
Yeah, so it is on page 37 of the answering brief.
Just give me a second. Man, this is a heck of a brief, buddy. Woo.
Yep. It's both these briefs were took a lot of work, both mine and the states. And they have hired the Solicitor General under Barack Obama.
I was going to ask you. I kind of thought it was going to be Obama, of course.
Yep. I mean,
arguing the black codes. That's unbelievable.
Go number 4.
All right. So here we are. So I can go ahead and read it if you want.
Yeah, if you just go to number 4, yeah.
Petitioners further argue that the 1865 Louisiana law should be disregarded because it was adopted. By the way, you're the petitioner, just so the audience knows. Alan's the petitioner. Well, his client is, but Alan's the attorney. This is Alan's case. I'm very proud of Alan. By the way, really quickly, I just want to tell you a little bit about the background of Alan. Alan is an inactive U.S. Marine. He's got a black belt in Brazilian Jiu-Jitsu. He's a good buddy of mine, and I've known him for years, and I'm just absolutely blown away. He's been all over the news. He's really just nailed it. But anyways, let's get
I'm
into
actually of counsel with Ehline Law on occasion. I help Mike out on it once in a while with some work. This takes up most of my time, though. So unfortunately, we can't, not as much as I would like, because it's always a pleasure to work with Michael when I have the opportunity.
I appreciate the kind remark. The other issue is we get a lot of people on YouTube who have basically, for lack of a better word, their own personal crusade with their own Second Amendment rights cases. But what Alan is doing, and what I'm trying to do with Alan, is to get laws passed so we don't have to help you with your personal crusade. So we focus on what we think really matters, which is getting the gun laws changed to what our founding fathers expected for the country. So give me a bunch of ones if you agree that's a better approach. But I'll go ahead and read, starting with number 4. Petitioners further argue that the 1865 Louisiana law should be disregarded because it was adopted as part of the Black Codes, BR 31 through 33. Black Codes are undoubtedly a relic, and this is the state saying this, right?
That's the official position of the state of Hawaii.
So Barack Obama's buddy is arguing, although the Black Codes are undoubtedly a relic of a shameful portion of American history, I guess that doesn't matter. But that does not mean the laws contained within them are irrelevant to the Second Amendment's historical analysis, because he's trying to couch in the Bruin historical analysis, right? And contemporary opponents of the Black Codes agreed that the Second Amendment did not authorize armed entry without the consent of a property owner. See D.E. Sickles' General Order, number 1. So since when is a general order law? I'm trying to understand that.
Well, it's one not. And more to the point, General Sickle here was, even if we say that it was law, I mean, he was referring to private property that is not open to the public.
Copy that.
Basically, what General Sickles is saying is that the laws of trespass always apply, and you can't carry a gun onto private property that's not open to the public unless you have an invitation, because, well, you don't have a right to be there.
It's right? Private property.
Yeah. But a business that opens its doors, open for business, head into the grocery store, there's an implied license to go in there.
Yeah.
Right? I mean,
absolutely.
The supermarket wants you in there. The tire store wants you in there. And in this country, this is going to lead to the state of Hawaii's next interesting argument is, in this country, there's always been a tradition that if you have an implied license to enter, then that includes being able to carry a firearm. And here, so as you can see, the state of Hawaii has endorsed the use of these Black Codes. And, well, I mean, for many reasons, that's not appropriate. But maybe if we're just going to try and keep it as academic as possible, a law that impacts a very small minority,
right, is
not historically similar to a law that impacts everyone.
So was Sickles a Confederate, just out of curiosity?
No, he was a Union general that had just taken over control of Louisiana.
So it says here that he issued a decree preempting South Carolina's Black Codes and providing that while constitutional rights of all loyal and well-disposed inhabitants to keep and bear arms shall not be infringed, nevertheless, this shall authorize any person to enter with arms on the premises of another against his consent. Petitioners also argue that the Reconstruction era precedents came too late. But this court declined review of petitioner's second question presented, which asked the court to decide the relevant time period court should look to when analyzing Second Amendment claims, and for good reason. The state is arguing there is no need for this court to decide that question here, as in Bruin and Rahimi. The public understanding that legislatures could require a person to obtain consent before carrying a firearm onto private property was the same in 1791 and 1868. But again, you distinguish the difference between private property and a private business that's open to the public, the implied license.
Yeah.
Do you want me to keep reading, or do you think we have enough?
No, I mean I just want for you to highlight the part about the black codes. I mean, we don't have the time. I don't have the voice to go through this entire brief with everyone, but yeah, I mean, that's the big thing. And then there's another issue is, assuming this doesn't work, the state of Hawaii is saying that the laws of the Kingdom of Hawaii should take precedent over anything else. And, I'll give them their credit. I'll try and lay out this argument, since thankfully we have, this sort of format that I can spend a little bit of time on this. So the state of Hawaii is not saying that the laws of the Kingdom of Hawaii trump the Second Amendment, but that's basically what they're saying. And here is their argument. The implied license that has always been the case in this country should not apply to Hawaii, because historically people didn't have the right to carry firearms in Hawaii. Therefore, they didn't have a implied license to carry a firearm. And,
but Alan, they did historically have the right to carry arms. In fact, ancient Hawaiian law almost commands males to protect women with their paddled shark-toothed paddles.
Well, according to the state of Hawaii, the most recent iteration of the laws of the kingdom during Kamehameha, especially Kamehameha III,
right? This guy
you couldn't carry weapons, and that means the history of Hawaii does not have an implied license to carry into public businesses. And so that's a nuanced way of saying the laws of the Kingdom of Hawaii trump the Second Amendment, right? They just take a couple extra steps to get there. And that just cannot be. There's no area of constitutional law that says that you trump the laws of a state. We should look to the laws of a state or the history of a state to decide a national standard on constitutional law. You don't have more rights in Montana than you do in Wyoming or Washington, D.C. or whatever, Kind
of like a marriage license, right?
Yeah. It's like, let's take a look at and let's take this argument to its extreme. Apply it to a few other places. Alaska was part of Russia up until, I believe, 1856, when we bought it for them. Are we now saying that the laws of the Russian czars apply to Alaska?
I guess only if you're the state of Hawaii.
Well, I mean, if the Supreme Court adopts this position, then that will be the law in all 50 states. Is that
unbelievable?
We'll have a state-by-state inquiry. That's why I genuinely believe the state of Hawaii cannot win this one, because their position is so extreme that it would destroy the idea of a national standard for constitutional rights. Instead, you'd have just, people, Montana gets to do one thing, Wyoming gets to do another, California gets to do another. And let's look at the territories. I mean, are we really going to require a historical analysis of Puerto Rico's laws or Saipan's laws? Right? I mean, Saipan was, it was in the middle of World War II. I mean, they just very recently became part of the Union. I mean, Guam, America, Samoa. I mean, that's just not how the law works. But that's what the state of Hawaii is putting its head on, is that the U.S. Constitution should not apply if you can show some sort of get some sort of state carve out based upon the history of a place that wasn't even the United States, right? And that just can't be the law.
Right. And in this case, we have evidence that the king disarmed his citizens because he wanted to establish absolute control. I mean, wasn't that
That's
the point of this?
exactly. That's
Wasn't that the point of this?
exactly. Yeah.
The Second Amendment was to ensure that it was memorialized that we had the right to overthrow an unjust government through force of arms if necessary.
That is true. And the bottom line here is the laws of a monarchy have no place in American jurisprudence. You can't.
I know, it's silly.
So that's where we're at. And, they're going to present this to the U.S. Supreme Court. And look, my opposing counsel, Mr. Katyal, I mean, I've argued against him before. He's an excellent attorney. Frankly, he's much better at presenting an oral argument than I'll ever be. He's presented, I want to say, 54 Supreme Court arguments today. He's one of the most accomplished Supreme Court advocates ever. But I have the history of this nation on my side. I have a genuine basis to argue a case that shows that my clients are being disarmed by an unjust law that's completely unrooted in American tradition. And for that reason, I genuinely believe the Supreme Court is going to find this case, is going to find the Ninth Circuit's ruling was completely erroneous and rule in my favor. And as a practical matter, I genuinely don't believe that the Supreme Court took this case to pat the Ninth Circuit on the bat and say, great job. I really don't.
Okay. Well, I just want to really quickly just scroll through all these amicus briefs. And as I scroll, we've had a couple people join the chat. Go ahead and explain what an amicus brief is.
So an amicus brief is a brief written by a third party, typically in support or in opposition to one of the parties, that says this is how the court should rule and why the court should rule. And it's typically, in this case, the National Rifle Association, the federal government, the Trump administration, 25 states, and a lot of other groups filed briefs saying I should win. For the following reasons.
I included the link to this document in the description, Alan, for the viewers.
Yeah. And the other side, we got like 19 briefs. I think the other side got 7. And
what was that? What was that? The World Economic Forum or something that joined them?
Yeah. Every town, some
Bill Gates.
I mean, one of the briefs was written by this group that sided with Mexico, that literally they were representing Mexico in a lawsuit to sue the American gun industry. And to try and say that Mexico gets to decide whether we can manufacture firearms, right? And the Supreme Court just smacked them down. So that's just where these people are at. I mean, these are people that don't respect our firearms culture or firearms tradition. And, another group is Every Town. Every Town is funded by Michael Bloomberg. Michael Bloomberg wants to be able to say what size of drink you get. Right? I mean, He genuinely believes, and I don't actually think that Michael Bloomberg's a bad person. I just think he genuinely believes that people need to be controlled for them to have good lives. That's exactly against what I believe. And he funds an organization called Every Town for Gun Safety that goes in there and tries to disarm people. And he's filed amicus briefs in many of my cases. His attorneys personally represent, the state occasionally. It's, that's what they do. And they're very well funded by Bloomberg. And I think that shows the sort of organizations are at issue here. These are, and then we've got, a brief by 7 states. I want to say California, New York. I can't remember what states were in there, but the usual suspects. But something interestingly is I got 25, they got 7, right? Or I think that says a lot that a lot of liberal states did not sign on to this brief.
Mm-hmm. So,
Mike, you pull up that amicus brief, the one by the states.
let me find it. So, I'm going to go ahead and share the screen. Give me 1 second, guys. And I'm still kind of struggling. The Restream sort of changed things, so just give me a second. All right. Looks like I'm getting it. Ah, what a nightmare. Give me 1 second, Alan. Sorry about the delay, guys. Did it pop back up? There we go. Okay. All right. So tell me where to scroll, Alan.
Okay, just scroll down. Keep scrolling. Scroll all the way to the bottom. We'll start from the bottom up. Okay. Scroll.
Every town right there.
Yeah, every town's one. Baltimore filed a brief too.
There's Baltimore.
Yep. Oh, here we are. It's amicus brief of the District of Columbia.
So, gee, I wonder. So, the Soviet Socialist Republic of the District of Columbia filed the document?
Yeah, on behalf of some other states.
Okay. And I wonder what size they picked.
Yeah, so you can tell right there. Yeah, let's get to those names. Can you scroll up a little bit?
Yeah. So let me see here.
You know, some of these states, it's sort of sad to see these names on there. Washington, Oregon, those were conservative states when I was growing up.
Yeah.
That says where this country's headed. And when Minnesota, a conservative state like Minnesota, has signed on to an anti-gun brief. You know, I mean, we're not.
Well, isn't Minnesota's population being replaced with illegal aliens and people who were brought in here by people trying to replace our population?
Well, something's happening because this is the Minnesota that I grew up, that I remember growing up, right? Oregon, Washington. I mean, the point I'm trying to make here is gun control doesn't just start and end in a particular location. Some of your viewers may be in Indiana right now and be saying, hey, why do I care about this? We don't have a default rule. We don't have gun control. That's California's problem. That's Hawaii's problem. It starts here. And then it spreads to places like Oregon, Washington. And don't think that it can't come to your hometown just because you live in a conservative jurisdiction. Because these laws spread. And, the Californians, they move out to your state and they spread these ideas. And all of a sudden, you see states like Washington, Oregon, Minnesota, I mean, Maine's shocking,
And by the way, we have Black Man 9038 joining us a little late in the show, but Black Man 9038, I appreciate you joining the show. Alan and I were just discussing that the liberal state of Hawaii is arguing the black codes, which were laws designed to keep black people from being able to defend themselves, is a historical analog basis to deny the citizens of Hawaii the right to keep and bear arms. So pretty interesting. Go ahead, Alan.
Yeah. So, I mean, I just want to point those states out, and now we could go to the amicus brief of states in support of me. If you could scroll out of that and go back to the docket, please.
Yep. Here we go. Hopefully you can see it. Okay.
Yeah. If you just want to scroll up.
Yep. I mean, I'm blown away, Alan. I've known you for years, and I always knew you were special. But how many cases have you argued before the Ninth Circuit now?
Go to brief of Mekai, Montana.
Let me Let me see if I can do this quicker by doing a search.
Well, no, it's right in the middle, November 24th in Montana. Yep.
November 24th.
In fact, it's interesting you say that. I've argued twice in front of the in-bank court. I don't remember how many arguments I've done, actually, before the Ninth Circuit 3-judge panel.
Yeah.
But I'm about to argue my third time in front of the whole court, which is in-bank. And, I don't know if it's for a fact this is true, but a lot of people have told me they think that will set a record for the most arguments for a private attorney before the in-bank Ninth Circuit, because in-bank almost never happens,
Yep. Yeah, no, it's guys, for people watching my chat. I mean, so guys like Dick, I get tingles up my spine when I talk to guys like Alan Beck and Dick Heller, because these are the guys that are making history right in front of you. And Alan's one of the most humble, unassuming guys you'll ever meet, but he's still a Marine. And he's got that gung-ho spirit, and he's doing this on his own dime. And so I'm going to put a link in the chat if anybody wants to donate to his cause, because he's doing this on his own. So Alan, I'll make sure, if you want, you can type it in the sidebar, but if not, I'm going to put it in the description for my viewers. And I do have that from you. It's just I failed to add it. But guys, I do encourage you, even if it's $1 or whatever, to donate to this cause, because Alan doesn't have a lot of backing, because he's not, you can see he's not a salesman. He does what his heart tells him to do, which is protect and defend the people of the United States. Go ahead, Alan.
Well, I made a decision a long time ago that I was going to file the cases that, maybe there wasn't, that people didn't want to file because the money wasn't there. Right.
Yeah.
And, for the state of Hawaii, I effectively am the firearms movement. And that's something that, I've done all the Second Amendment cases of note there. Certainly all the wins I've litigated. But I've added up, and I can't remember how many cases I've won, but I've actually won the most of any Second Amendment attorney in the country. And
yeah.
I want to say it's 24 lawsuits I've won in Hawaii. And then, something in the 30s, if nationally, for Second Amendment cases. If we count settlements and where the government simply affirmatively got rid of their policies after I filed suit, it's in the 30s now. Watching the state of Hawaii completely change their system it's been the honor of my life. It's made it so that I've been able to see real reform in the state of Hawaii over the years. There's a lot of issues I've been able to see. Tasers were banned there. Knives, butterfly knives, you couldn't carry, all sorts of different weapons. And we've gotten rid of that. We've overhauled the registration system. So, that's been a good thing to see. And even in California, I have, I see one of my readers, I believe, is in your chat. I didn't know we had a crossover. I recognize Kopoto.
Oh, nice.
Yeah.
Oh, yeah. Welcome to the show, man. And we have another guy he wants me to interview, Dawood. I'm sure you remember him, the concealed carry case in California. Vaguely. Yeah, I think he was San Bernardino. He's in a battle of his own, and he's doing it pro se, and he's had a lot of luck.
Oh, sure. I didn't remember that being the last name, but by the way, I don't know if I'm doing this right, but I've put a private chat. I've sent you a private chat with the link. I don't know how to put the link to the GoFundMe.
Well, what I'll do, private chat. Let me take a look. Here we go. Yeah. Because I'm still learning how to use all this stuff too. I'm going to drop it over right now. So guys, if you want to donate money to Alan's cause. Well, the problem is, Alan, is this doggone link is too big. It won't display on YouTube. It's too long.
That's all
So
right.
I'm going to drop it right now. I'm going to edit the video, guys, while we're live. And I'm going to encourage you. I'm going to put it under sources. I'm going to put donate to Alan. Just give me 1 second. And I will drop it right now. Yeah, because you guys have to understand, Alan's not rich and neither am I. And so we spend our spare time focusing on the Second Amendment, but we have to work on other cases to pay our bills because there really is no money in these Second Amendment cases. And so it's a labor of love, and we can't take everyone's case, but the cases that Alan does take are cases that have a high propensity to change the laws for everyone, including people like DeWood, so he doesn't have to fight anymore pro se or pro per. So what we like to do is focus on the big picture because we simply can't help everyone. We have families to feed and we have to bring in an income. So anybody, if you can go to the description on my YouTube channel right now, under the description of this video, you might have to refresh it. You'll see the link. If you have it in your heart, if you've got the extra Federal Reserve notes, anything would help. Again, because Alan's doing this out of his own pocket to a large degree. Go ahead, Alan.
Well, another amicus brief I'd like to point to you is the Trump administration actually filed an amicus brief in support of my case. So we have the official position of the federal government is we should win this case.
So how long has it been since the government has supported the Second Amendment? I can't remember a time where our government...
I think this would be the first time that at the merit stage, the federal government's ever done so.
Wow.
And this is definitely going to be the first time the federal government has ever presented argument. They presented argument in both Heller and McDonald for the government. That was during a different administration.
Right. Anti-Second Amendment. Yeah.
This time they're on our side.
I'm going to try to find that brief now. Any idea where that might be?
Well, if you scroll back, just go back up, scroll down.
Under Buckeye.
Keep going. Oh. Scroll down.
And by the way, guys, the link to this
November 24th brief of United States.
And by the way, guys, the link to this website that has all these documents, I put it for you in the description. I mean, this is unbelievable. You've got the United States of America. Finally, we have someone in office who actually supports the Second Amendment, which is absolutely shocking to me. Alan, no wonder everybody hates this guy, right?
Yeah.
That's just shocking to me. So what is the government joining you on? All of your arguments? Do they expand upon? Wow.
They're saying that this law is just grossly unconstitutional.
By the way, guys, I'm in El Salvador right now, and there's like M80s and firecrackers going off in the background. I guess they're getting ready for the new year out here. So if you hear that, no, it's not a war zone. They're just celebrating that they have a president who finally brought them freedom from the criminals that Biden imported into our country. So give me a bunch of ones for Bukele. So go ahead, Alan. So the DOJ is basically joining you on all of your arguments.
Yeah. I mean, they have a little bit of a different take, but essentially we have the same arguments, right? I mean, they're pushing, they're basically saying we should win, and they'll be arguing alongside me. The way it will work is I will argue for 20 minutes and the federal government will argue for 10 minutes. Then the state of Hawaii will get 30 minutes.
Wow. And when is this hearing?
It's January 20th in Washington, D.C. before the U.S. Supreme Court.
Man, guys, give me a bunch of ones for Alan. I mean, this guy is doing this by himself. Imagine, I mean, this is to go before the Supreme Court. Usually you're going to need a team of like at least 5 or 6 minimum lawyers. Alan's doing it all on his own. So please understand, when he can't take all your cases, he's doing this by himself. And he's also handling cases with me so we can pay our bills that actually pay us something. And we can't represent everybody pro bono. It's impossible. I know a lot of people hate us, say we're fake, say that I'm a fake lawyer because I won't take their personal crusade. But I'm trying to change the laws with people like Alan for all of you with one fell swoop, as opposed to cases that don't have the ability to get us where we need to be. So go ahead, Alan.
So, I'm very grateful that the federal government took time out of their day and picked my case out of all the cases to push for it, right? And so here we are. It's it's going to be a good day because my understanding is Deputy Solicitor Sarah Harris is going to be presenting argument. She's argued in front of the U.S. Supreme Court quite a few times. And, this is going to be my first argument before the Supreme Court. This will be Neil's something like 54th argument before the Supreme Court. But you know what?
Yeah.
He also bills $3,500 an hour. So God bless him.
Woo! $3,500. Well, Alan, I'm sure with this huge YouTube show that I had tonight, you're going to make millions.
I'm sure.
So guys, you can see that, we're fighting an uphill battle here. And this is one of the very few times in history that the Department of Justice has joined a private attorney's brief with an amicus, and they're going to be arguing side by side with Alan. So to me, this is a historic moment. And you guys, the ones who made it to my show tonight, are experiencing a living piece of history. Don't forget that. This is a really big deal. And so, keep your prayers with Alan. I think he's going to win. And I think that this is going to be a game changer because it's going to eliminate all these specious arguments that we need to apply laws that prevented Black people from owning guns or prevented Indians, like the California government argues, from owning guns, which was the whole purpose of the Second Amendment, which was to be able to protect yourself from absolute power by the ability to throw off all enemies, foreign and domestic. Does anybody have any questions that they want to ask Alan? Thanks, SS Contracting. So SS Contracting, I think you're also pro se America. I think that might be Dawood right there.
Well, I believe it was Vallejo was the fellow's last name in Riverside.
Or San Bernardino. There's so many of them, man, and we just can't help everybody. It's just impossible unless we had somebody like the NRA funding us, or Rifle and Pistol Association of California, California Rifle and CRPA. Alan, I can't believe that you're able to do this and still train jiu-jitsu and hold a black belt and all the stuff that you do. I mean, my hat's off to you, man.
Well, I appreciate that. It's been a long time doing this, but like I said, it's been good to see the state of Hawaii start to really reform their system because of the work we've done.
Yeah. And look, the people of Hawaii have just as much of a right to keep and bear arms as anyone else. I mean, it's not like we're in Canada where the police tell you, oh, if someone breaks into your house, just call the police, right? Because the police are always 15 minutes away when seconds count. Oh, don't do anything. Just let them have their way with your children and your wife. And if you do anything, we're going to send you to jail. I mean, we don't want an America like that, right? That's what California is trying to do, right, Alan?
Yeah, that's what we're fighting against. I've got a case out in California. I'm currently on appeal, but we got rid of the Billy Club ban in California. I did that with my buddy Steven Stambolia, and that is a horrible law. Any stick is a billy club if it's being used for self-defense. So what that means is that if you have a baseball bat in the back seat of your car, you are committing a felony. If you have it for self-defense. If you go to the batting cage, hey, you're fine. Well, guess what? who does that law really impact? People that can't afford a lawyer, people that don't interact very well with the police.
I wonder who that might be.
Selective enforcement. And I was very proud to get rid of that law. So right now, billy clubs are legal in California, have been for the past couple of years, but the state of California has appealed that up to the Ninth Circuit. And we're in a fight to try and keep that law, that trial court ruling, and if I win this one, the precedent I set the Supreme Court is going to help,
Yeah. So Alan, there's a bunch of questions in the chat. Is it possible for you to scroll down and answer some of them? We've got questions like, what is the GOA? Were you were restricted to certain questions at the Supreme Court? You see all those?
Not yet, but I'm opening it up.
Okay. Yeah, I mean, while you're here, because I don't want to answer these questions, this is your case, like what's the GOA, all that, just take a look at the ones that you think that you can answer that require an answer.
Some of this stuff isn't.
Yeah, just anything that looks palatable to answer. You can see my audience is pretty vast. I've got libertarians, liberals, conservatives. They all have their own points of view, and that's why I like having them.
Yeah, let's see here. I'm trying to. I'm reading something about a rolling pin, baseball bat. Sure, there's a right to repair firearms, certainly.
And include the name of the person asking the question, too.
That's Ryan Labs. You're asking if you have a right to repair. Well, you have a right to acquire firearms, right? Or else there's no right to own them. If you can't acquire them, you have to get them, right? You have to get them somehow. So as a corollary to that, especially during the founding of our country, how were most firearms created or acquired? They were built. And so you have a right. If you're living on the frontier, maybe you could have gotten a gun, but a lot of these guns were home built. So you have a right to build firearms for your own personal self-defense, and you certainly have a right to maintain them, or else you're going to have to go buy yourself another firearm, right? So as a part of the right to acquire firearms, the ancillary right to your right to bear arms, you have a right to maintain them. Yep, that's right, Ryan Labs. You have a right to self-built firearms, and there are cases on this issue tackling the ghost gun issue. I'm not a part of them, but I think there's one out of Delaware and one out of Nevada, and I only can read the top couple comments, but I did notice somebody talking about nunchucks. And yes, you have a right to own a nunchuck. That was done by the great Second Amendment attorney Jim Maloney in the great state of New York. And
go ahead. Yeah, nunchucks, he calls them. East Carbon Exposed asked that question.
Yep. So the trial court in New York is the only court to ever rule on that issue. They found that you have a constitutional right to nunchucks. So yes, nunchucks are part of the Second Amendment right.
So Alan, I'll read some of these questions since you're having a problem scrolling. USA Inc. 183 KKR asks, what about a tire iron?
Well, I mean, if you're using it for self-defense, then that falls under the classic definition of arm, which is anything a man takes up into his arms to cast at another in defense. So sure, a tire iron would be there's some amount of constitutional protection to a tire iron.
He also asks about Australia, if I can just intercede a little bit. So Barack Obama says we need common sense gun laws like Australia. Do you know anything about the Australian gun laws?
Well, let me tell you, you basically can't own anything other than a handgun over in Australia. I mean, that's just simple truth.
But who can own a handgun in Australia? That's the question.
Well, no, I don't think you can own anything other than a standard citizen can't own a handgun.
Got
Is
it.
my
Yeah.
understanding.
Yeah.
The only thing that you can own are rifles
Right.
for hunting, and those are bolt action rifles. And then it's very difficult to own one.
Right. And they'll use a pretextual reason to ban firearms, like importing illegal aliens into their country who cause
Yeah,
mass
absolutely.
riot. Now, SS Contracting says hopefully it will help with them trying now to make knives illegal to carry, which is an arm. So I guess he's saying that it'll help people who are trying to make knives.
Yeah.
I guess that's the Billy Club case. Now, Cupono 1 says SCOTUS limited us to question 1. Is it possible for the scope to widen during the hearing?
It's unlikely, Caputo, but the only avenue for that is with the Black Code law, because the Black Code laws from 1865. I've structured my argument to be A, you shouldn't use it because it's a Black Code. B, even if you accept a Black Code in theory it could be used, there's not enough laws at issue here. So
Right.
It's an outlier. But C, if you accept these laws are valid in theory, then you can't, then it's still not relatively similar because the law is too new. So the court would have to accept that a Black Code was relatively similar in order for them to get to the issue of, is it old enough to be a historical analog? And I don't think the court's going to do that because I just don't see the court accepting a Black Code as being a relatively similar historical, piece.
Okay. Now, what's the matter? You asked, what's the GOA?
I don't know what you're talking about.
The Gun Owners Association of America.
I mean, I know what GOA is, but I mean,
he wants to know what it is.
It's a gun rights organization.
All right. And then Rhinelab says he did a dance after the bill was signed and he said, go get them. I guess, okay. I get you. Now, what's the matter? You doesn't believe in case law. He thinks that the Second Amendment shall not be infringed is enough. And I can't say that I disagree, but Alan, I mean, don't you think we kind of are forced to work within the system that we have in order to protect?
Yeah, there's there's a lot of things that are good in theory, but at the end of the day, I mean, if you have practice law, you gotta fit within the system,
Now, Rhinelabs asks, or he says, Washington Governor Bob Ferguson used to be Attorney General, gave me the small claims game plan for the right to repair. Okay, well, that's cool. I'm just trying to get to some of these questions. I like to answer questions from my audience because they're doing me the honor of at least joining the show. Let me see here. You got a lot of support. We got East Carbon Exposed. What's the matter, you? All these guys giving you a bunch of ones. That's kind of cool.
Well, brick petitions. Let me tackle that one. Brick
So
petitions.
Go ahead.
Is any weapon too dangerous to be considered outside of the Second Amendment? And now I'm going to give you my personal views because that issue is still being decided in the court. So I can't give you a legal test because that legal test is still being decided right now. It's my personal view that the Second Amendment was to put Americans on parity with the standard infantry force that at any given time. So during the colonial era, if the infantry had muskets, you had muskets. Now, you'd have a right to an M16, arguably maybe even a saw, right?
Yep.
But and because it's to put you on equal footing with the infantry soldier of the U.S. military and of other militaries, then that's probably the extent of it. So if, I mean, there's some things, for example, I used to be a tank crewman, a long time ago. There's some things that are on a tank that are they're crew served. For example, you'd have a 50 cal machine gun. That's crew served weapons. So that's outside of the definition of an arm because it's not bearable on the person. It takes two people to operate.
Does that come from the Miller case?
That comes from the Heller case.
Right, but didn't Heller cite Miller as a precedent for that?
It did, but not for that proposition.
Copy that, okay.
And I did rely upon Miller, though. So that doesn't actually answer your question of if something's too dangerous. I'm just showing there's some things that are not protected by the Second Amendment because, a bearable arm is not crew served. A cannon, while you probably should have a right to a cannon, that's not part of the original intent. It was to deal with, weapons for the militia, weapons for the infantry. So then there's, to actually address your question, you have stuff like things that are too dangerous. And again, I used to be a tank crewman. If you want to take out a tank, then you'd use something like a javelin, right?
Yeah.
Javelin is not standard issue for the standard infantryman, right? And that's something that you probably, you just don't have a right to have under the Second Amendment. Whether or not you should or should not have one, that's a matter of public policy, but it's not codified within the right. So, that shows, that sort of delineates, God bless you was a motto. That shows that the Second Amendment has a scope, a historical scope, a legal scope, and that's what the government needs to act within. And you have a right to an AR-15. You have a right to a billy club. You have a right to a taser, a knife. You have a right to a lot of things. And no, it doesn't protect the right to nuclear weapons. It never did. The Founding Fathers did not think that you had a right to, under the Second Amendment, to, a massive, to weapons of mass destruction. However, they did give you a right to deadly weapons, sort of weapons that you could use to supplement the armed forces in time of invasion, or if need be, in a case that the government became tyrannical, to be on equal footing with the government's military.
Now, Brick Petition, do you see his question? He says, I believe it was written to fend off an immediate skirmishes from a corrupt government. What do you think about that?
You're absolutely right, Brick Petition. I mean, that is a facet of the Second Amendment right. It also protects the right to self-defense, like against a burglar, right to hunting, right to target shooting. But the core right really is for military readiness. So you're absolutely right.
Now, isn't the primary function of the federal government, I mean, correct me if I'm wrong, to protect our borders from foreign invasion and not flood the country with illegal aliens and give them everything for free?
That's absolutely right. And, the Second Amendment protects the right of the people to keep and bear arms. And
who are the people?
The people are certainly U.S. citizens. And, there's a very good argument for long-term lawful residents that have been allowed into this country come into here underneath our laws that have developed sufficient ties to it. For example, I had a case this year that dealt with Micronesians. Micronesians are here in the state, here in America, pursuant to the Compact Free Association. They're allowed to come here due to a treaty. It has a lot to do with the fact we used their country for nuclear testing during the Cold War, along with a few other islands. And look, the reality is those nuclear tests did a lot of damage, a lot of cancer in those countries. But our military need those tests so that we could, show the Russians that we meant business. So those countries took a hit, and we let them come here now because, we sort of owe them, considering how many of them got cancer, do our military testing. They don't need a green card or a visa to come here. They just proof their passport's sufficient. Well, Hawaii said, since you don't have a green card and you're not a citizen, it doesn't matter how long you've been here, you can't own a gun. Is that right? you've let those people in. They're our neighbors, they're our friends, and I got approached by a gentleman named Billy Peter. Billy Peter has been living here for around 25 years. Married a woman here. He's got a daughter. He's held down a job every single one of those years he's been here. Currently works the school system as a maintenance guy. And the state of Hawaii said, hey, you don't get to own a gun. Because I said, this guy fits the definition of a member of the people. He's lived here for decades legally through our invitations, never committed a crime. He's doesn't abuse drugs or alcohol. He pays his taxes. He's got a family, and you know what? Why shouldn't he? So I said that was a violation of both the Second Amendment and the Equal Protection Clause. And I thankfully was able to get an injunction in that case. And now Billy Peter, along with all the other Micronesians that live in Hawaii, can exercise their Second Amendment right to keep.
Congratulations. That's awesome, Alan. Now, really quickly, Brick mentioned well-regulated. And I know that the Marxists on the left who hate the ability for us to defend our families with firearms say that that means well-regulated, like, a building code. But if you look at the historical meaning of well-regulated, my understanding is it means well-trained. Can you expound upon that for us?
Oh, that's absolutely right. I mean, our founding fathers want us to have the right to be able to train with those arms, right, and be part of the polity, right? I mean, they wanted citizens that were fully engaged in society, trained, and had weapons at all times so they could, know how to use them when they needed to use them.
But Alan, did they mean that somebody over at code enforcement needed to be doing the training?
Absolutely not. They thought that, you have the right to train with a firearm. That's something the court in Zell said. Also, Drummond v. Robinson. These are contours of the Second Amendment right. They're being expounded upon right now. And, the government does have a right to tell you can't train with your gun. That's the bottom line.
Now, Alan, Brick Petition made a pretty amazing statement, and I agree with him. He said, our founders knew that nothing lasts. They gave us a court to finalize any petty conflicts. We are all responsible for the posterity. Gosh, that just gave me chills. What do you have to
post?
Man, I'm going to put it up on the screen. Brick, that was prophetic, man. Woo! That is right on the money. So, Alan, we are we're about an hour in now, and it's 12 o'clock for me, and I've been up since 04 working on briefs, so I'm wiped out. And I know that you've got to get up early tomorrow too and work on briefs. So everybody, give me a bunch of ones for Alan. Please take a look in the description. He's got a donations link. Again, he's arguing a case before the United States Supreme Court for you. And he's funding this primarily out of his own pocket with donations. So if anybody, even if it's $1, I don't care what it is, just show your support for Alan. I'm not looking to be a holder of money or Federal Reserve notes for him. I just want to support him because he's a brother in arms. He's a fellow Marine, and I really care about the guy. And I wanted you guys to learn a little bit more about Alan and what he's doing for we the people. We need more patriots like Alan. Give me a bunch of ones for Alan. Give me a bunch of thumbs up. Ryan Labs, it's really good to see you. Mr. DLRU, and what's up, my good friend? Thank you for coming, man. It's been a while. Let me see. I just want to thank everybody. USA Inc., Ryan Labs. Hope I didn't miss anybody. It wasn't the biggest show tonight, guys, because as you know, I was out for 90 days. So I'm basically having to rebuild my channel from scratch. But for me, it's not really about the number of views or how many likes. It's about how many people actually showed up who care about their country. And so I really appreciate you guys joining me tonight. Alan, do you want to say anything in closing? Any questions that you want to respond to before we go?
Oh, no, I mean, I just appreciate everyone showing up. And, I hope you all can wish me the best for January 20th. I'm really looking forward to it.
All right. And with that being said, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. God bless everybody. I'll try to go live more in the future, but I do appreciate you guys joining me, especially Brick and Wassa. It's good to be with the old crew again. I'll talk to you guys soon. Bye, Alan. Thank you.